Good evening, friends. Today, I will not give my introduction as a hedge fund manager. Rather, I will give my introduction as LLB student, as a law student. And honestly speaking, I don't have words to thank you to the Supreme Court of India. I strongly believe that on time to time basis, Honorable Supreme Court, Honorable High Courts, sharing their opinions in the form of judgments. And it is our moral duty, our legal duty, especially those who are in the law profession, to read these judgments carefully and also update the people, who are not from the law background, who do not knew anything about the law, that this is what Supreme Court or the Honorable High Courts delivered. But before that, I would like to thank you to the Honorable Chief Justice of India, Chandrachud sir, for giving a statement that judiciary should be reaching to people, rather, people should be reaching to judiciary. I consider this as one of the remarkable judgments, remarkable statements made by our Chief Justice sir. And he's very right that judiciary should be reaching to people. Rather, I'm very convinced and happy that the Chief Justice sir is doing so many initiatives, like very recently he spoke about how to resolve tariq pe tariq so that lengthy frameworks, lengthy litigation processes can be reduced. Honorable Chief Justice sir launched the new app of Supreme Court of India. He came up with an idea of pre-screening cost and multiple initiatives Honorable Chief Justice sir is doing. And once again, I have no words to thank you, Supreme Court of India, for that. Supreme Court is also known for making landmark judgments. There are multiple landmark judgments which Supreme Court made in each sphere of our jurisdiction, our jurisprudence, which include criminal cases, the taxation system, and many landmark judgments Supreme Court came up with. And today I would like to cover, with sincere thanks, gratitude, and honesty, about one of the landmark judgments delivered by Honorable Supreme Court of India. Rather, I have no words more than gratitude, I can say, because this landmark judgment is delivered by the respective Constitution Bench of Supreme Court of India. Constitution Bench is one of the highly respected, highly, I would say, seniority, bench we are having in Supreme Court. And this judgment which I'm talking, is by the Constitution Bench of Honorable Supreme Court, dated 2013, precisely speaking, 12th November 2013. This judgment is on Lalita Kumari versus Government of UP and others. And this judgment is by 5 judges, which include the Honorable Chief Justice and respective judges. In this judgment, the very important piece is that Supreme Court issued a notice to Union of India, Chief Secretaries of all state and Union territories, Director General of Police, Commissioners of Police, to the effect, if steps not taken for the registration of FIR in India means First Information Report, immediately, and the copies thereof are not handed over to the complainants, they move to magistrate. In this 41-page judgment, you can clearly see that I have even highlighted using a yellow highlighter. You can see that because I am reading this word by word. Rather, you would be very surprised that I'm going to be reading this 5 times. This is my first time I am done, and after I am going to be done with first time, I would be reading it again four more times, because one of the, I would say, so much knowledge you would be driving out of that judgment, so much inferences you would be drawing from the judgment. I doubt whether books would be able to give you that. But once again, it's a very hard task. But after this hard task, you get so much knowledge. Credit to Supreme Court of India, respected Constitution Bench. This judgment is about two important things which Supreme Court at that point of time was looking to highlight. Basically, whether it was there was a question before Supreme Court of India as far as the FIR is concerned. FIR stands in Section 154 CRPC. CRPC means Criminal Procedure Code. Criminal Procedure Code. In this judgment, various people shared their opinion. Like, let me give you the few names. Mr. S.B. Upadhyay, the learned senior counsel. We have Dr. Ashok Dhameja, the learned counsel from CBI, Central Bureau of Investigation. We have Dr. Manish Singhvi, learned additional advocate general, State of Rajasthan. We have Mr. G. Siva Balamurgam, the learned counsel for appellant in criminal appeal. We have Mr. R. K. Dash, the learned senior counsel appearing for State of Uttar Pradesh. We have Mr. Shekhar Naghade, learned senior counsel appearing on behalf of State of Maharashtra. We have Miss Vibha Datta Makhija, the learned senior counsel appearing on behalf of State of Madhya Pradesh. We have many respective learned counsels in this regard, and I express my sincere thanks and gratitude to all counsels who shared their facts, their vision, their ideas, their deliberations about 154. Because Section 154 in CRPC, criminal procedure, is all about the FIR, which is First Information Report, and I express my special thanks to all learned counsels in this regards. But what really, I would say something which I have no words to explain, let it be honest, because on page number 10, I got to know that the issues before Constitution Bench of the Court, Supreme Court of India, arises out of two main conflicting areas of concern. And it is whether the immediate non-registration of FIR, leads to scope for manipulation by the police, which affects the right of the victim, complainant, to have complaint immediately investigating upon allegations being made. Whether in cases the complaint information doesn't clearly, this is second point, disclose the commission of a cognizable offense, but FIR is completely registered, compulsorily registered rather, then does it infringe the right of the accused? One thing which we need to understand is the word manipulation by police. I'm not saying this word, it is the court himself which is saying this word. I have a document which I did a printout. This document speaking about sovereign immunity. I would be covering a sovereign immunity in later stages of my videos. This document is about how the innocent people being implicated in wrong cases by investigating agencies, and honorable courts on time to time basis stressed the requirement that innocent people should not be implicated. Henceforth, when I was reading to this judgment by Honorable Supreme Court Constitution Bench, I stressed on a word manipulation by police. I would like to take a hold here for a tactful reason. I would like to take a hold. Today, I took a printout of one of the remarkable judgments made by Honorable High Court of Jammu and Kashmir and Ladakh. And this judgment, basically, it was pronounced on 25th August 2021. And this judgment is about 156.3, so which is section 156, subsection 3, which gives the right to magistrate for an investigation by the police if the offense is cognizable in nature. So basically the scene is like that, you first go and register FIR under 154.1. If police is not listening you or they are running away from their responsibility, then you can go 154.3, which is superintendent of police or the senior officials. In case they are also running away from their responsibilities, then you can contact the magistrate directly, which falls in your jurisdiction under 156 CRPC, Criminal Procedures 156, subsection 3. And this gives the power to magistrate, to order police to investigate any cognizable offense. However, there are multiple issues relates to that. And one of the issues that relates is whether a preliminary inquiry is required or not. We can have variety of cases. We have matrimonial disputes. We have many kind of disputes which we have. And unfortunately, Honorable Supreme Court himself and various Honorable High Courts on time-to-time basis share their displeasure about the rampant misuse of the matrimonial acts by women. Rather, in this, judgment also, at one places, Honorable Supreme Court of India also shared their displeasure. Like on page number 11, Honorable Court said, however, on the other hand, there are number of cases which exhibit that there are instances where the power of the police to register an FIR and initiate an investigation thereto are misused, where a cognizable offense is not made out from the contents of the complaint. A significant case in this context is the case of Preeti Gupta versus State of Jharkhand 2010 Supreme Court case SCC 667, wherein this court has expressed its anxiety over misuse of section 498A IPC Indian Penal Code with respect to the large number of frivolous reports were lodged. Please note a word that Supreme Court is using two words, which is known as misuse of FIR investigation, and secondly, Supreme Court is using frivolous reports were lodged. Right? So Supreme Court himself agreed to the fact that till what extent these matrimonial issues are being frivolous, fake, for the sake of arm twisting and all. Honorable Delhi High Court also shared their opinion on IPC 354, and I'm going to be making a video separately in this regard. I can't cover the whole 41 pages, but I can only request that everyone who is from a legal fraternity, and if you are facing any form of matrimonial dispute or any FIR, it would be very pertinent. It would be very important for you to have this into consideration. Rather, you would be very surprised if I take a hold of that. Even a judgment. This judgment is delivered in 2013. Please note, 2013, and we are in 2022, which means precisely 9 years. Precisely 9 years ago. And this judgment of Honorable Jammu Kashmir High Court is delivered 2021, which means around 1.5 years ago, you can say. And in this judgment also, Honorable Jammu Kashmir Court took the help of Lalita Kumari case. This is a judgment copy which I downloaded from the internet. So this is not my copy. Neither any wordings in this hall being manipulated by me. In this judgment also, which is Jammu and Kashmir High Court, they took the reference, or they took a reliance, in legal we call reliance on Lalita Kumari judgment, and they mentioned thoroughly. And honorable, Jammu Kashmir High Court made it clear that preliminary inquiry is must. Preliminary inquiry is must. If I coming back to this judgment, which is original by Honorable Constitution Bench of Supreme Court, if you refer the last page, you would get a fantastic jotted points by Supreme Court of India. Fantastic jotted points by Supreme Court of India. I cannot cover all jotted points, but I would like to cover the first two jotted points. Number one is, in view of the aforesaid discussion, we hold registration of FIR is mandatory under Section 154 of the Code if information discloses commission of a cognizable offence and no preliminary inquiry is permissible in such situation. If information received does not disclose a cognizable offence but indicates the necessity of an inquiry, the preliminary inquiry may be conducted only to ascertain whether cognizable offence is disclosed or not. Honorable Supreme Court is also saying, as what type of cases where preliminary inquiry is to be conducted will depend on the facts and the circumstances of each case. The category of the cases in which preliminary inquiry may be made as under matrimonial dispute, family dispute, commercial offences, medical negligence cases, corruption cases. Supreme Court also said that the aforesaid are only illustrations and not exhaustive of all conditions which may warrant preliminary inquiry. It means Honorable Supreme Court is very clear that in matrimonial dispute, family dispute, there is a requirement of preliminary inquiry. We all are aware till what extent the matrimonial disputes are being exaggerated. We all are aware till what extent the matrimonial disputes are being hyped. We are aware the kind of physical, mental, legal, social, financial, all kind of cruelty the accused been through. We all are aware about the figures given by the Delhi Commission of Women, the National Commission, about NCRB, National Crime Record Bureau, and respective agencies about the fake and frivolous cases of rape, Section 376, registered in India. In this regard, this judgment by Honorable Supreme Court Constitution Bench would be is a remarkable judgment, and we should be thank you to Supreme Court for that. If you are having similar dispute, and if you are genuine, completely accurate, you did nothing, you are being implicated, framed by your spouse, or probably, I'm talking about matrimonial specifically, then you can take the reference of this judgment. Please read this judgment carefully, holistically. I further repeat, please do not go only the last two pages. They are the gist and the jotted points by Honorable Supreme Court. But having said that, it would be better if you read the whole pages of the judgment line by line and underline the important fact. It would be very helpful for you, because the kind of knowledge, facts and figure you would be getting would be enormous in nature. This is what I can say. Even Honorable Jammu Kashmir High Court take the reliance of this judgment. And guys, you would be very surprised to know that in this judgment, when you would be reading the whole judgment, you would get to know there are various other judgments on which the respective attorney generals, respective councils have reliance on. And it's very knowledgeable, I would say. Like you would get to know the view of the Supreme Court on various issues, just like general diary, just like issue, on matrimonial dispute, just like the power of the investigating officer. There are various, of course, it's a hard task. You need to take a printout of all judgments. You need to study line by line. You need to note line by line. It's a very hard task. And I'm currently being through that hard task. But at the end, gratitude, if I have a better word, I would have gone through it, but I would sincerely thank you to the Supreme Court and Honorable Constitution Bench, which includes the Chief Justice, sir, for giving this remarkable judgment and this paving the way even after 9 years. Because this judgment delivered in 2013 and Honorable Jammu Kashmir judgment delivers in 2021, that even after 9 years, around 8 to 9 years, this judgment is helping people. With this, I thank the Supreme Court. I am very clear on one thing. In my legal career, I would be reading as maximum judgments as possible. Whenever I am doing my preparation, I take the judgments. My reliance is always on the judgment. And I love to see that how the honorable courts express their pleasures, their displeasures, their comments, their opinions, their remarks in the form of judgments. And this judgment, which I'm talking, Lalita Kumari judgment, it is by Honorable Constitution Bench. Rest, I leave on you with special regards, thanks to Honorable Supreme Court of India. Special regards, thanks to the respective Attorney Generals, Assistant Attorney Generals, the councils of various institutions who spared their knowledge in this judgment. But unfortunately, the matrimonial disputes are being exaggerated and misused to the highest extent. And we need to stop that. This is what I can request to the Honorable Chief Justice, Sir, Chandrachud, Sir, to kindly consider this. Thank you. This is Rahul Magan from Treasury Consulting. You know my personal number, +91 9899 242 978, +91 9899 242 978. Thank you very much and have a great time ahead.